Wire case dealing with the firing of a medical marijuana patient by an employer. He lost that case, but he won the case of Garden Grove versus the appellate court, which the California Supreme Court ruled that police must return marijuana to persons from whom it's been improperly seized. Joe is a graduate of Stanford University and the Yale Law School, and served as a law clerk to the man of the hour, Federal Judge Vaughn Walker of the United States District Court for the Northern District of California. Joe?
Thanks, Eric. So no matter what happens this November, Prop 19 has had a profound impact on my life. Every time I open up my Facebook page, it's dominated with status updates of folks who are either for or against Prop 19. What surprised me was how many medical marijuana folks are against Prop 19. I guess I would have thought it would have been almost unanimous in favor of Prop 19. The principal proponent of Prop 19, Richard Lee, who's here, is a medical marijuana activist and certainly intended this to benefit medical marijuana patients. You'll see me probably biting my lip a fair number of times as I stand up here because as Chief Counsel of ASA and having this divide within medical marijuana patients, I'm constrained for a change in what I can and can't say. You're not going to hear me say that I'm either pro or against Prop 19, but I'll just try to I'll divide this into two components. The first half I'll talk about what we've seen before and try to answer some of Theshia's questions, what we've seen before in the medical marijuana context, and what that may tell us about what would happen if Prop 19 passes. And then I'll also talk about some of the concerns and some of the benefits that medical marijuana patients have expressed with respect to Prop 19. Prop 19 is a very ambitious law. I mean, when you contrast it with Prop 215, the Compassionate Use Act, it's remarkably more ambitious. Prop 215 only provides, or arguably only provides a defense, an affirmative defense to criminal sanctions. At the time, the proponents of Prop 215 actually said you can still arrest anyone for a marijuana offense. And that's been, we've had our nose rubbed in that in pretty much every single case that we've litigated. And the courts narrowly construed it. In the first few years after Prop 215 passed, the courts very narrowly construed Prop 215 as only providing a defense to criminal sanctions. Prop 19, by contrast, was clearly written, because it was not a blank slate, it was clearly written with some of the issues we faced in the medical marijuana field in mind. It has an express anti-discrimination provision. It talks about landlord-tenant law, talks about distribution systems, all of which were absent in Prop 215. But what's lost in all of this, and what makes my job interesting, is despite the fact that Prop 215 is only a defense to criminal sanctions, or arguably only a defense to criminal sanctions, it means more than that. Any law has ripple effects when you look at it in the context of other laws. And Prop 215 has to be looked at in the context of other laws. Because there are laws that only make sense to treat marijuana patients or medical marijuana patients in the way that they did because medical marijuana was illegal. But once medical marijuana becomes legal or non-criminal, however you want to put it, these types of treatments don't make any sense. And I'll go right up front, I'll talk about the case I disdainfully refer to as my biggest loser, and that's the Ross versus Raging Wire decision. Ross versus Raging Wire involved the question of employment discrimination. And it was our argument that under California's Fair Employment and Housing Act, which is California law, it's not federal law, which requires a reasonable accommodation of disabled persons, that reasonable accommodation would be you don't fire somebody simply for testing positive, for using a substance that makes them a more productive worker. And that argument made sense to at least 2 members of the 7-judge panel, and obviously did not make sense to the other 5. And what happened in that case was, and I'll quote the dissent, the first line of the dissent in that case, in a decision utterly lacking in compassion when interpreting the Compassionate Use Act, the California Supreme Court decided that California's Fair Employment and Housing Act afforded no protections to disabled medical marijuana patients. And they did so based on this cockamamie theory, and I think all lawyers get a little bit emotional when they talk about their biggest losers. This cockamamie theory that because it's criminal still under federal law, it's not a reasonable accommodation to require an employer to accommodate off-site marijuana consumption. But federal law really had nothing to do with it. There's, as we heard the earlier panel talk about federalism, there is no direct conflict with requiring this accommodation, and an employer can comply with both state and federal law simply by accommodating medical marijuana use. So the court got it wrong. But we moved on. We anticipated this result. The day the court announced their decision, State Senator Mark Leno announced a bill, actually at the time he was an assemblyman, that passed both houses of California's legislature. Unfortunately, it was vetoed by Governor Schwarzenegger, who will not be governor the next time we introduce this legislation.
We hope it isn't bad either.
So moving on to the case that I refer to as our biggest winner, is a case called Garden Grove versus Superior Court. And in that case, the court did actually look at the interplay between various laws. Looks at the medical marijuana laws in context of the laws that require the return of property under California law, and actually made the interplay work. And they said that when the cops improperly seize your medicine, the courts have an obligation to give it back if you file a motion for return of property. In that case, it's a published decision, which is now final, and so it's unlikely to be disturbed. In another case called Butte County versus Superior Court, it involved a cop being shown a doctor's rec, and the court said, not because of the medical marijuana law, but because of the other constitutional rights that medical marijuana patients can assert their constitutional rights in civil court just like any other citizen. So we've kind of made up for the Ross versus Raging Wire debacle with these two other cases, I hope. So switching to what this means, or what does Prop 19 mean for medical marijuana patients? And it's very important in the way that the two most important phrases are notwithstanding any other law versus nothing in this act shall authorize. And this is where there's a great deal of confusion, because many medical marijuana patients are concerned about the fact that you cannot, that Prop 19 says nothing in this act shall authorize you to consume marijuana in public. Well, it doesn't actually say there are any criminal penalties. It simply says status quo is maintained. So I think that concern hopefully will be shown to be overblown. Similarly, Prop 19 says nothing in this act shall authorize smoking of marijuana where minors are present. Well, this doesn't mean Prop 19 is making it criminal to smoke marijuana where minors are present. It's simply maintaining, again, it's maintaining the status quo. So again, I hope that it's the case that those concerns are proved to be exaggerated. Where medical marijuana patients' concerns may not be so exaggerated are, Prop 19 does add new penalties for distributing marijuana to minors. And there may be some litigation involved. Let's say you're a medical marijuana patient who's 20 years old and a 25-year-old sells you medical marijuana. Does this somehow trump the earlier act? Richard Lee shaking his head. No, I would agree that that's probably not the case, but it may be a concern that will be litigated in the courts. Another area where Prop 19 could create some very, very interesting litigation is in the area of dispensing. And there's a case called Qualified Patients Association versus City of Anaheim that we've anxiously been awaiting the decision now for well over a year. And the court has on its own motion vacated the submission now twice, which is remarkable. And the last time they admitted basically that the decision would be so important that they needed an additional 30 days to consider what they were going to do. And they gave themselves until August 18th to reach a decision. So on August 18th, I expect you will get a decision that will cause the greatest media frenzy in the last 10 years. And that decision, we don't know exactly what is going to happen, but it's possible that what happens is the court could say localities cannot ban dispensaries because that conflicts with the Medical Marijuana Program Act, which allows for dispensaries. And if that decision comes out that way, because of some language that's contained in Prop 19, which allows localities to regulate dispensaries, although Prop 19 does say, or otherwise, I think it's authorized marijuana use. So I think there's a strong counter-argument. But there may be an argument that Prop 19 might somehow reverse the Anaheim decision if the Anaheim decision comes out in a positive light. And so that's another possible ramification of Prop 19 in the medical marijuana community. One other almost certain ramification is it will lower the prices of marijuana. I mean, it depends on exactly what the how the taxes are set, but based on the economics, if the taxes are too high, people will turn to the black market, and all of this will cause a decrease in the price of marijuana for medical marijuana patients. I would think that most medical marijuana patients would think that's a good thing, but again, I'm neutral on Prop 19. With that, I will close. Thank you very much.
Joe, thank you very much for sketching out very well some of the further issues that